judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains the court's opinions covering many years. The site also contains a detailed directory of North Dakota licensed lawyers, biographies of state judges, listings of officials by counties and judicial districts, guides to using the North Dakota judicial system, and links to other legal resources on the Internet. A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the state court administrator and other staff. The clerk of the Supreme Court receives documents for the Supreme Court. The clerk supervises the court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal
Honorable Supreme Court of the State of North Dakota is now in session.
Good afternoon. Please be seated. We are here at the time set for oral argument in file numbers 2026-0063 through 65 in the interest of KB, GB, and MW children. Sitting this afternoon are Justices Jared Tufte, John Jensen, Douglas Barr, Mark Freese, and I am Lisa Fair McEvers. Arguing for the appellant this afternoon is Kara Crosspar, and for the state, Mr. Charles Stock. Ms. Crosspar, you may proceed when you're ready.
Good afternoon, Chief Justice, Justices, Counsel. May it please the Court, I'm here representing the mother. I'm using pseudonyms in all of the names for this. Christine. There's 3 children at issue. Carl, Greg, May. May is the youngest. Excuse me, I said that opposite. May is the oldest and has a different father, Matt. Carl and Greg are younger, and they are the ones that ICWA applies to. So I just want to kind of set the context. There's 2 issues before the court. The first is whether the court erred in denying a motion to vacate the default order and actually hold an evidentiary hearing that my client, Christine, could actually participate in. There was evidence presented at the dispositional date, but she was denied the opportunity to participate because default had already been entered against her. And then the second issue is whether the court lacked sufficient evidence under 2719.1013 and didn't comply under 2719.105. So that has to do with the ICWA findings, that there was insufficient evidence under those 2 statutes regarding the qualified expert witness. So I want to kind of go through a little bit of the time frame of this to start with the notice problem, or the default order is really more the problem. So the need for protections came October 17, 2025. The petition was filed November 10th, 2025. There was an initial appearance on November 14th of 2025, and the summons was issued that same day. A status conference occurred then on December 1st. December 2nd, at that status conference, default orders were entered, but on December 2nd, the court vacated that default order, saying that their summons was not, they weren't properly summoned, the parties were not. And then they issued a new scheduling order, written order, identifying December 29th, 2025 as the trial date, or excuse me, now I'm saying it wrong, December 29th as the status conference and January 2nd as the trial date. December 29th, Christine appeared, and there was a status conference. The court explained that that he did not anticipate there would be prepared to go to trial on the 2nd. I think it was specifically about the ICWA expert. So on the record, on December 29th, they discussed, well, we're not going to be able to have trial on the 2nd because there's just not going to be enough time to get the expert, or to get the evidence necessary. So at that hearing, the court orally said, we're going to have another status conference on January 26th. And I assume that's to see if all the witnesses and evidence was available, and then schedule a trial on January 30th. So that was the information that was provided orally to Christine at the December 29th hearing. The issue becomes notice, and what she was noticed of and whether default was appropriate. So I argued 2 different things under the notice of default. One, that she wasn't properly noticed by written summons or a written new scheduling order or something to tell her that she needed to appear. My other argument is that and I did find an error in my brief that I want to correct. She didn't appear at the status conference, what was initially the status conference, January 26th. That's when the default order went in. She did appear at what was scheduled as the trial, January 30th, and tried to vacate the default. On the January 30th trial date, she explained that she tried to get into the January 26th hearing via Zoom, via reliable electronic means and couldn't get in. The court said, well, you weren't authorized, we didn't have any Zoom information given to you, and that was an error, which if you look, and this is what I wanted to correct in my brief, I cite the wrong transcript page, or not, record. So at the status conference on the 29th, the page 7, I believe it is when the court says they were given Zoom information. So that's record. So I'm in 0014, at record 65, January 26th. I want to make it clear because my brief cites January 30th, and that's incorrect. It cites so there's 65, 66. Record 65 is the January 26th. Record 66 is January 30th, and I believe in reviewing it, I cite to 66, which is inaccurate and doesn't really make sense when you look at what I wrote. So essentially, for clarity, 65, January 26, my client attempts to call in, doesn't call in, and the court puts on the record, well, she had the Zoom information indicating that she could have or would have or should have appeared via Zoom if she wasn't going to appear in person. That's on the record at page 7 in R65, January 26. Record on January 30th, this is R66, again, page 7. The court says they weren't given Zoom information or permission to appear by Zoom, and I think that that's contrary to what was previously said, so I wanted to point that out. I did point it out in my brief, but the record site was off, so I wanted to explain that. So under those two theories, one, she wasn't properly noticed, and I know that the state is citing Rule 10, that this is a continuation, and so she was properly given notice.
You mean Rule 9, don't you? Or
possibly, maybe.
when notice
Yes.
can be given orally?
Yeah, Rule 9, 10 is default, so I think
Yep.
that's what I was thinking of. So Rule 9, I know they're citing to that, but what was continued was the trial date. The January 2nd trial date was continued at that hearing because the status conference is what everybody was at. And so they said, we're going to continue the trial date to the 30th. And so she didn't have, I don't believe that she had accurate notice of that she needed to be in person on the 26th, which is essentially what the court ruled on the 26th, excuse me. So what the court ruled on the 26th is that she's not here in person, and so we're going to default against her, which then I don't think is compliant with Rule 10. If you read it, it says hearing, but it can't possibly mean every single hearing, initial appearance, status conference. That doesn't make any sense because in your summons, you're summoned to, you're supposed to summons to present yourself and defend against the allegations. That's what the summons is for. So that's the dispositional hearing. That's what you're being summoned to court for, is to defend against the allegations. Also, I cite the North Dakota Century Code that specifically says that you have a right to appear and defend, 2720.2-13-1, I believe. It doesn't make any sense to read that rule as broadly as the state is reading it. And even the district court was reading it, because if you think about, there's a fundamental constitutional right to the custody to parent your children. So if you miss a status conference, you essentially default that right. But if you look at a comparable civil proceeding, any appearance, it removes it from default. I'm thinking of Rule 55. So in a civil context, which doesn't have to do with constitutional dimensions, it could be just property, it could be a contract dispute, it could be anything that falls under the civil rules. You have more protections than you would on a juvenile proceeding where a constitutional right to parent your children is involved. So I don't think the reading of that rule as broadly as if you miss a status conference, you're now in default, makes any sense. When you've appeared, it makes sense if you've had an initial appearance, didn't show up, had a status conference, didn't show up, then we got to trial and you're still not there. Or even if you didn't have those other hearings, you had an initial appearance, nobody showed up, you have a trial. That makes sense. If you're given a trial date, a dispositional date, where you're told, hey, we're going to have the hearing where you can present evidence, you can cross-examine witnesses, this is the date that's going to happen, that's when you're supposed to show up and defend, which wasn't the case here. I don't understand the way that the state is reading it, or really the court is reading it. In addition, my alternative argument under that is it doesn't make sense under the Rule 16 to reverse the default, to vacate the default. Because we're supposed to be doing what's in the best interest of the child, and it's not like they weren't having more hearings. The January 30th dispositional hearing went forward. They provided evidence and testimony. They also allowed the father to remove his default, yes, to voluntarily consent, but and gave the same thing. I'll vacate your default in order for you to voluntarily agree to the disposition. But I'm not going to vacate it if you're going to have a contested hearing, which then we're going to have a contested hearing anyway. Well, we're going to have a hearing and put on this testimony from the ICWA expert.
Was the offer to agree to the disposition or to agree to the factual predicate for the court to enter its disposition? I mean, was it
procedurally
to agree that they're in need of protection, but not necessarily to agree to the 12-month removal or whatever the court might choose as a disposition?
Oh, I see what you're saying. Like, it was to agree that the children were in need of protection, and then it would move to the disposition. So yes, in regards to, but she would then have to essentially admit the petition allegations, which is what happened with the father, which doesn't. It is not in the best interest of the children. If you're going to have it really makes no sense if you're going to have testimony anyway.
How's it not in the best interest of the children? Isn't the referee concerned about further delays, the children being in this environment, the lack of stability, the lack of a plan in place? I think it's a pretty large leap to say it's not in the best interest of the children.
I'll try and there's quite a few, so I'll try and take them as you've sort of relayed them to me. One, this is an allegation, which the state has to prove. So a default doesn't do that. So that's the first problem. The second problem is it delayed because we're having the hearing on the 30th anyway. The hearing could have happened. He could have removed or vacated the default and had the same hearing he had it, although allowed my client to actually participate, allowed her to call witnesses, allowed her to testify if she chose to testify. It didn't delay anything is my point. There was a couple other in there, and I'm sorry, there was a list that you went through, but my point is that there is a presumption. The presumption is on that there is a fit and willing and ready parent. That is the presumption, that is the constitutional guarantee, that every parent doesn't even need to be the best parent, but it is a fit parent, and there should be refraining of interference by the state, and that is a U.S. Supreme Court decision. That is our court's case law. That is standard, and so the presumption is with the parent. So default doesn't address that, which is sort of my point about why do we grant more. The reading the district court is having of the rule for default for 10 doesn't make any sense in the context of the only other area where you get default, which would be civil procedure.
But we've talked about the difference between default under the juvenile rules and then under Rule 55. The court doesn't just enter a judgment like you would under Rule 55, a default judgment. They still have to hold some type of evidentiary hearing for the state to present the evidence, which happened.
Yeah, but it's also 55B says the same thing. A default judgment may be entered against the state, its officers or agencies, only if the claimant establishes a claim or right or relief by evidence that satisfies the court. There's also, and I don't know where it is in 55, but there's also the need to put on proof in other contexts, but I think B under 55 kind of goes to the same issue. The issue with default in juvenile is that you have, especially where you have ICWA problem, which I'll transition to here in a minute, where you have evidence the court is supposed to be provided you need to have that evidence. It's not a you can come to this conclusion just based on the allegation, just based on the petition. You have to have evidence supporting that the children are needing protection, and that in the case of ICWA, it's actually even further, which goes to the two of the children, where you need that causal link, so that the causation of the parent's home and the harm to the children is under 2719.1013. So you have to have a causal link that the court has found. There has to be evidence that is presented that there's a causal link between the parent, the home, the conditions, whatever, the facts, and the harm to the children, which doesn't exist. So I guess I'll transition into the second part of my argument, but also in ICWA under Section 5, so that's Section 3, 2719.1013, Section 5, is that the qualified expert needs to be someone familiar with the home, the children, the circumstances, someone who can then give that expert testimony because they're familiar with the situation. And that's completely lacking here. We don't have it. I argue two things, and I want to make that clear. One is I don't think that this qualified expert witness, based on her testimony, even agrees with the need to remove the children. So her testimony is it's the tribe's opinion that returning the children to care would likely result in serious physical, emotional damage to the children at this time. So she's saying that's the tribe's opinion. And then she goes on to clarify, I would like to clarify that's not my opinion specifically. That is the opinion of the tribe after being
Aren't you reading the
staffed.
context in with your voice, by the inflection of your voice?
Maybe, but that's how I'm reading it. Like, if it was her opinion, she wouldn't need to clarify anything, is my point.
Well, it could also be read that's not only mine, but also that's
Right, she doesn't need to clarify that. There's no clarity needed there. If it's her opinion as well as the tribe's,
You've not seen a witness bolster their own testimony before?
I have.
And that's precisely Mr. Stock's argument.
That
and
is
I
his
think-
argument, but it also doesn't go, and this goes to my other point. I don't think that's what was happening, but aside from that, even if it was, let's just agree with him, although I don't, and say that that's what was happening. We have completely insufficient facts supporting her. She just says that there's a need to remove them. There's no causal connection. So she doesn't say, she said she reviewed affidavits and orders. She actually doesn't say she reviewed it. She said it was staffed, essentially. So I don't know who reviewed it, which is part of my argument. I don't know if she's familiar with the evidence, wasn't even presented, the factual history of the case, the affidavits, the court's orders. I have no idea. It's not in the record. And she doesn't clarify that, and no one asks her that. The court doesn't ask any questions. Well, what specifically did you rely on? I mean, the court's not a ferret, neither is this court. I would challenge you to look at the record, her testimony, and can you say what she based her opinion on? You can't. There's other than the record at large. She just says, I looked at she doesn't even, I'm actually giving her more credit. She never says she looked at the record. She said it was essentially staffed. Someone looked at the record and then came to this conclusion. Which, how are you going to cross-examine that? I wouldn't know where to begin. If she's not the one that actually reviewed this information, you lack someone familiar, so you lack Section 5. In addition to that, you lack causal. I don't know how else to explain that. If you reviewed an affidavit and then said, yeah, the children are in need of protection. If they stayed in the home, it's likely that they will suffer physical or emotional damage. Okay, I need the supporting fact. How would this court ever even review that statement? It's conclusory. I have no idea what it's based on. I don't know where the causation is. And she doesn't explain it, and the court doesn't ask for it. And so her testimony is just wholly on its face insufficient. She said somebody somewhere in the tribe reviewed the record and then found that there was a need to remove the children. Based on what? The state couldn't point to it, the judge can't point to it, it's not in his order as to what the causal link is. She doesn't ever say what her interaction with the children is, she doesn't say what her interaction with the mother, or the parents, specifically Christine, my client. She doesn't say if the interactions, or the review was done by her, what she's forming her, if I'm conceding, which I'm not, but if I did, hypothetically, concede that Mr. Stock is correct, that she's bolstering her own testimony, you would still need to know what she did to come to the conclusion that she's saying that this is necessary. And we just don't have any of that on the record. We don't know what facts she used to support her conclusion. If it is the same as the district court's order. We don't know what the district court relied on, other than the expert's testimony, to come to the conclusion that they needed to be removed. But he doesn't know, because he didn't ask, nobody asked any questions. Nobody asked any follow-up, nobody asked any, hey, did you talk to the kids? Did you talk to the mother? Did you talk to the father? Did you visit the home? Did you talk to the social workers? What are you basing this on? And if you didn't, and you're relying on somebody else, what information did they? I understand she's an expert, and that experts can, rely on reports and what would normally be hearsay, but you still have to identify what you're using as the basis of your opinion, so that the basis of your opinion can be challenged, can be attacked, can be cross-examined. In this case, we don't have any of that. So it's just on its face deficient. There's not findings that this court could even review. I don't know how you would begin to review the record, which is essentially what she said, and what the district court I think it was judicial referee, but still, the juvenile court relied on to come to the conclusion that these children needed to be removed. This kind of goes back to my point about default. Their overlapping concept is, why are we defaulting against someone when we need evidence to support that these children are in need of protection, that they have to be removed from this home, otherwise they are going to suffer physically or they're going to suffer emotionally. And the only evidence to support that is an individual who we don't even know reviewed anything, personally reviewed anything, or did anything. And for those reasons, I would ask this court to reverse the the juvenile court's finding that these children were in need of protection. As to Carl and Craig, I think just a straight reversal, because they put on their evidence and it was insufficient. If the court agrees with me that the court should not have allowed, or should have vacated the default, then it would get remanded back and could potentially have a new adjudicative hearing for all three kids. Thank you.
Thank you, Ms. Grossparr. Mr. Stock, you may proceed when you're ready.
Good afternoon. May it please the court, counsel. Be remiss if I didn't mention a good deed done by Ms. Grossparr on my behalf. I've been really short-staffed, and I emailed her when I was preparing my brief. I didn't have any staff, and I asked her if she would send me her Word version of hers so I could do some cutting and pasting and other things, and she was kind enough to do that, and I appreciate that. I think we need more cooperation like that in our profession. So with that, I'm going to just jump into the notice or service issue. I've spelled those matters out in my brief. I'm not going to completely rehash that, but what I'd like to point out to the court is that I think the rules were properly followed, and in juvenile matters, you kind of have to be quick on your feet, because in Trail County, we have several of them going on at one time, and some of them need to get to trial quicker than others, just from a timing standpoint and how long the children have been out of parental custody and so on and so forth. So this happens all the time. and oral notices of continuances are a common thing. And in this case, it actually worked, because I won't say the name, but because the mother stated that she knew about the hearing. That's in the record 66, page 7. First she said, I didn't have a vehicle, and when I tried logging into the Zoom, I struggled finding it, and I got a hold of my attorney later. So she knew about it. She knew about the January 26th hearing that she failed to attend. I'll note that her attorney, this is record 65, page 6, record 65 being the transcript of the January 26th hearing. Her attorney states, I've had very sporadic contact with the mother since the last hearing. I know she was arrested again looks like last Wednesday in Walsh County on 5 new charges. I have not heard from her since her arrest, and I don't know if she's still in custody. So lots of dynamics going on here, but I disagree with appellant's argument that there wasn't proper notice, that any laws or rules were not followed or applied correctly. To the QEW matter, I'll just say it felt like appellant was kind of saying that in her brief that the QEW used information that wasn't even of court record. Well, there wasn't any objection by the attorneys, both of whom were there on behalf of their clients. Secondly is she testified, that is the QEW, that she had read the affidavits in support of shelter care, and that she had been in constant or consistent contact with Agassiz Valley on developments of the home or developments in the case. And one thing I think that's important to point out is that in the GAL report and the affidavit in support of CHIPS, there's ample evidence demonstrating that the mother here was homeless. In fact, she was homeless when the...
Where is that in the court's findings?
It's in, excuse me one second. Oh, in the findings?
In the findings.
Oh, I don't know whether they are. I don't think they are.
No, and I'm looking at the court's findings, and they're pretty sparse. And if I'm looking at the order and at the transcript alone, the only thing that I can go by is the qualified expert's testimony saying the tribe agrees, or there's a finding, and I think it's under P of the court's order, for the following reasons: children's exposure to escalated domestic violence involving parents concerning adult functioning and decision-making abilities to protect the children from unsafe conditions. But what's in the record to support that finding?
Well, it would be in the affidavit in support.
And no testimony there's no testimony on the record from that affidavit? Is that enough?
Well, I believe it is. The affidavit was submitted into evidence at the December 1st, 2025 hearing, as was the GAL report. So it's part of the evidence.
So they are in the record in the underlying case, but don't they have to be, is this a separate petition?
No. Same petition. The initial default that happened on December 1st.
So they're somewhere else in the record.
Was vacated because we had served by publication pursuant to the rules.
Well, if it's vacated, don't you start over?
Well, the court issued a new summons and allowed the petition to stay in effect. It didn't request my office or me to submit a new petition. I think if the petition's been filed, then it's a matter of service after that. So that's what happened here.
We have a case saying those documents have to be moved to be admitted and received.
That happened at the December 1st.
Yeah, that's what I'm checking. That did actually happen.
It did, yep.
Thank you, Mr. Stoll. That was sort of my question too. I'm like, just looking at this and that hearing, I wasn't seeing it.
And I anticipated that would be asked, and yeah, it's definitely in the record. I'm aware of the case law that requires that now. So with that, I would just ask that you, unless you have any other questions for me, that you affirm the district court's, juvenile court, I should say, decision's in order. Thank you.
Thank you, Mr. Stock. Ms. Grosspar, you have 5 minutes on rebuttal.
Yeah, so I wanted to review the record that Mr. Stock was referring to the December 1st, what was initially called the status conference with the original default. That then they put on Ms. Duval, so it's the CPS worker, I don't know what they're called, the child protection worker. The problem is, again, what the court said, that was vacated for lack, there was no one there except for the state, and they again presented this evidence as part of their default, which was then vacated. So that evidence was not submitted into the new. The default was vacated. The case wasn't closed, which I think the state is arguing because the default was vacated and the petition continued on, the evidence that was presented also continued on, which is not true. That
We have a case that says that vacating an order vacates everything that's been admitted to evidence up to that point.
There's no cross-examination, there's no testing of the default was simply to put on evidence that the court could rely on and make its default order.
So the attorney for your client wasn't there at that?
No, she was there.
Okay.
But again, if my client,
She knew what was going on, so for the court to rely on it.
no, that one was that one was vacated because she didn't get properly summoned. There was no proper notice, no proper summons. So if she had appeared, she would have waived summons. So and the court, to its credit, says, oh, there wasn't proper service, I'm vacating that order. And so to say that then evidence that was presented during a default hearing should then somehow magically be admitted at the next default hearing, it doesn't make any sense. You remove that evidence because you said there wasn't appropriate process.
Don't we normally say that the evidentiary record for a case survives from one hearing to the next? So if at one hearing evidence is admitted, it's in the record, the evidentiary record for that case until the case is done. I thought that was the normal rule.
But we're talking about, I don't know how else to explain it other than like if you had a trial and a mistrial, you're not using evidence from the first trial to support the allegations from the second trial. That you'd have to resubmit the evidence. That's the point is that there wasn't proper process. And so she didn't appear and defend. Yes, her attorney was there.
Suppose at the end of a hearing, a court issues two distinct orders, and there's evidence admitted that's relevant to both. One of the orders is vacated. Which evidence stays in the record? Maybe that's a strange hypothetical, but I'm trying to figure out what kind of an order vacating it erases all the evidence leading to that order, because I don't think it's every single time you vacate an order, you erase the evidentiary record.
I'm saying the reason that was vacated was because she wasn't properly served.
It was
How was she going to appear and defend?
So was it vacated as to her? What about all these fathers? Were the fathers ordered?
I think it was vacated across the board. He said there wasn't proper summons.
On any of them?
Yeah. That was my reading of the record. I also think this is sort of getting away from my main point, which was that you need the QEW. And she did show up on the 30th, but her testimony was, how is there a causal connection to what she testified to? How is there a causal connection? What did she say about the home, about the circumstances, meant that the children were in need of protection? There is nothing in this record identifying that. There's also nothing in this record that identifies what she did to personally familiarize herself with the case. She said records were reviewed, but she said it in a way that it sounds like the tribe reviewed, but it's unclear from the record. So you don't have your qualified expert witness providing sufficient evidence, sufficient testimony to support the trial court's order. So above and beyond the fact that I don't think the evidence that the state is pointing to on December 1st doesn't get us around the fact that the qualified expert witness is completely lacking in sufficient evidence. And I also still stand by the fact that I don't think that she agrees with the tribe, and that's what she was saying. But even if the court doesn't find that, what she did say is not sufficient to remove the children. Thank you.
Thank you for your argument this afternoon, Ms. Krauspar, and yours as well, Mr. Stock. This case will be taken under advisement, as all cases are, and this court will stand adjourned until 1:30 on Monday, June 22nd, 2026.